podcast of the Potomac Law Group International Trade Practice area. We hope this will be the first of many, and we would appreciate your feedback on today's discussion and other topics that you'd like to hear us address. My name is Mike Mendelson. I'm a partner here at Potomac Law Group in the International Trade, Corporate, and Government Contracting Practices. With me also is Dr. Axel Spies, who is one of my partners and an old colleague as well, and it's wonderful to be working with him again, who is barred not only here in Washington, D.C. in the United States, but in Germany, and is an expert on international trade relations as well as cross-border data privacy issues and a variety of international compliance issues as well. And of course, our colleague and partner, Roger Banks, who is primarily focused on international trade compliance, especially in the tariffs area. So it's especially great to have him here today. He's also a member of the Bar of the Court of International Trade and the Court of Appeals of the Federal Circuit, where international trade court decisions are appealed, and has extensive experience in tariff issues, anti-dumping, and trade litigation as well. So we're here today to talk about the Supreme Court's ruling on last Friday, where it struck down the Trump administration tariffs, which when it held that IEEPA did not grant the authority to the president or the administration to impose tariffs. And then the next steps, what has happened and what are we likely to see? So I think maybe just to kick it off, let's talk a little bit, just for a few moments, about the ruling and its immediate aftermath. So, Roger, I'm going to go to you first, please, and let us know, based on your extensive experience here, what you think of the opinion and its immediate aftermath.
Okay. Yeah. Well, thanks, Mike. I'm really glad we're able to do this today. The learning resources case, learning resources was the name of the case, decided at the Supreme Court, upholding the two lower court opinions, which held that the statute, the International Emergency Economic Powers Act, or IEEPA, does not authorize the president to order tariffs on the basis of, in response to the national emergency that he has the authority to declare. So the decision can really be boiled down to a pretty simple statutory interpretation, that the statute authorizes the president the action that he can take to address international economic emergencies include, among other things, the regulation of imports. The administration took the position that regulation of imports includes imposing tariffs, but the Supreme Court, in learning resources, decided that regulation of tariffs in the 6-3 decision does not include, regulation of imports does not include tariffs. And the effect is to say that in other words, Congress specifically and expressly delegate to the president the power to tariff, as it's done in many other statutes under which the president does have the authority, the express authority to impose tariffs. But in terms of under IEEPA, the president can regulate imports, but he cannot impose tariffs according to this decision. So that's basically the essence of it. And then the question is whether the court was silent on whether or not tariffs that have already been paid under the IEEPA orders, which extend to many countries and many products really around the globe, whether the importers who have paid those tariffs since the beginning 2025 are entitled to refunds of the tariffs they paid that are now essentially unconstitutional.
Well, that's a good point, and I think that's probably something that's on everyone's mind. And there were actually a couple of articles in the Wall Street Journal in the past few days, and I'm sure there will continue to be many articles in both the trade press and the popular press. Hundreds of millions of dollars in tariffs have been paid under IEEPA. Now that the court has struck them down, what can companies do to try and obtain a refund, either through an administrative procedure, through a court filing, and at this point, do we have any idea on the likelihood as to whether that will be successful, or will we see any retroactive tariffs that are imposed under different authority? And I'd open that up to both of you, of course, and then to everyone here, because I think that's what's on everybody's minds. How do I get my money back? Can I get my money back? And the government is probably thinking we don't want to give the money back at this point. So,
yeah, to just chime in here, all that reminds me of Maggie Thatcher, the legendary Iron lady, talking to the European Commission saying, "I want my money back." So I hear from many companies overseas, they're checking into that, but they are on the fence right now because they don't know what to do. And I think that two ways to deal with the situation is to file a protest and at the same time consider action at the ITC. And maybe, Roger, you can explain what that means.
Right. Well, it's interesting because originally the administration had said to the Court of International Trade that, at least for the parties before it that had been litigating the case in the lower courts, that if it was ultimately determined on a final non-reviewable decision that the IEEPA tariffs were unconstitutional, that they would pay refunds of those tariffs that had been paid. But now they've taken the position, the president and senior administration officials have said pretty clearly that they intend to deny claims for refunds. So I don't know whether, well, in terms of how those refunds can be obtained by importers who have paid the IEEPA tariffs, as I said in the dissenting opinion, the court made no mention of how that would occur and that it would be likely a mess, to use Justice Kavanaugh's terms. And that's probably what it is right now. It's anticipated that the Court of International Trade will issue some kind of guidance, or maybe or order the Customs and Border Protection, CBP, to formulate or to publish regulations on a process for importers to request refunds. So basically, if the administration is challenging, as they seem to be prepared to do, challenging the importer's right to receive refunds in the wake under the terms of the learning resources decision, basically right now the importers, what they need to do is preserve their rights to refunds in the event there's ultimately a favorable decision for them. That because there are statutory deadlines for requesting refunds that are, like, even in the event that ultimately it's decided that they are entitled to refunds, if they haven't preserved those rights through an administrative process, at least they probably will be barred from obtaining them. So
what is that statute of limitation, Roger? Because the clock is definitely ticking.
That is also open to question, because there is under the administrative process, what you do typically, if you think you're entitled to a refund, is you file a protest, and that protest can't be filed until after liquidation. That means about a year after the import takes place. So then you have 180 days after liquidation. So it comes out to be about a year and a half after importation. You have to file a protest, otherwise you lose the right to do so. And then after that, if the customs, say CBP, denies the refund request, then you have 2 years to file a claim in the CIT to contest their final determination on the refund. But the administration has the possibility of saying, actually, the statute of limitations begins to run as of the Supreme Court decision in learning resources, which means 2 years from February. So that would mean to file a claim, if the process is to directly file a claim in the CIT, that you would have 2 years to do that. maybe from the time of import, maybe from the time of liquidation, maybe from the time of the decision. It's really unclear at this point how that would work. But all of those are colorable claims that could be asserted to bar claims. And so I think, depending on the importer's circumstances, the prudent thing for many importers will be to file both a protest at the CBP at the proper time and also to file concurrently, simultaneously, an action with the Court of International Trade. That way, if it's ultimately determined that the protest is not the proper method, you have the claim in the Court of International Trade, and you're not barred by the statute of limitations. On the other hand, if you don't file the protest and you just go right to the court, you have the possibility of having the court determine that you didn't exhaust your administrative remedies and be thrown out on that basis for lack of jurisdiction. So basically, and so I think it's prudent, depending on the importer's circumstances, to file both. That would be the most, the safest way to proceed.
It sounds like please, Axel, go ahead.
For our overseas audience, could you explain a little bit? They're usually exporters. Would they be allowed to file a protest? I would assume no. And also, what does the term liquidation mean? We know liquidation is getting rid of companies. So could you explain that for them a little bit?
Yeah, liquidation. Now, when you practice customs law, you just throw out that term as if everybody understands it, but obviously it's a specific term of art that's used in the regulations. But basically, it means the end of the transaction, the import transaction with the government. So it's the time they have to look at all the declarations you make, to and determine that they are correct, the classification, the valuation of the goods, so forth. So usually within a year, they will liquidate the entries and say, okay, it's done. You paid your duties, you paid what you owed, and it's over. Now, if you disagree, you have 180 days to protest their decision. Because you may say, these goods are not subject to IEPA, or they're qualified for an exemption. They may say, no, we think they are, so you're paying the duties. And so then they liquidate. Then you have 180 days to protest. So that's, and I'm sorry, what was the other question you asked?
Whether an exporter, like someone in Europe, could file a protest, and where would they file the protest? I would assume they cannot, if they are not importer of record. Maybe you can explain that a little bit.
Correct. Yes, they have. If the exporter is also the importer of record, which is possible, it's not the typical case, then the foreign exporter could file a protest. Anyone who is an importer of record, the importer of record is the party that files the official entry documents with customs when the goods are imported, and they pay the duties and make the declarations of what the goods are, the tariff classification, the value of the goods, and so forth. So the importer of record is the one on record as having made the importation. They are the ones that pay the duties and the ones who are entitled to any refunds. Anyone else does not have standing directly to file a protest or file a claim.
So it seems that at the bare minimum that clients are advised and companies are advised not to dawdle and not to wait, but to start preparing what their options might be, because the clock is ticking. And it does sound like the time period that is going to kick off this particular round of protests, whether it is subject to the standard liquidation rules or if it is subject to the date of the court opinion, is still up for grabs. But I think something that you mentioned here is very interesting as well. I mean, if we assume for the sake of argument that there might be some kind of a refund, then you have customers or people in the commercial chain who are not the importer of record, but contractually those duties may have been passed on to them by the importer of record, by the manufacturer, seller, distributor, customs broker, what have you. What do we do about potential contractual claims and the likelihood thereof? I mean, is that going to be basically a lot of hard knuckle negotiation? Are there other types of arguments? Basic construction of contract rules would say that you have to look and see what's the what's the actual text of the contract and have to look at it on its face rather than what is the intention behind it first. But where do we think those types of claims or issues are going to wind up at this early point in time?
Yeah, you're asking, Mike. I think certainly if there's a contractual obligation where the say the exporter, the producer, would remunerate or in some manner reimburse an importer of record for duties paid to customs. There may also be an express requirement that in the event that, well, I don't know, it depends on the terms of the contract, but and what you're saying is right. They could be contractually obligated to pay any refunds they get of duties paid to the party that they contracted with. And by the way, the statute requires that refunds be paid with interest, which could be very significant since the ultimate resolution of this case may not be 5 years or so. So, or whatever it is, it could be fast, I don't know, but so they would probably be required to refund or pay the refunds to the party they contracted with, plus interest depending on the terms, assuming that, best case scenario for the exporter. That's an interesting point too, because suppose an importer is entitled to get refunds but doesn't act promptly and is barred by the statute of limitations, or doesn't follow the right process, then they still may be on the hook to the exporter. You had the obligation to obtain those refunds. They weren't actually owed under the U.S. Constitution as decided by the Supreme Court. So now you must pay them to us, even though you didn't get the refund. I could foresee a scenario like that where it could be, maybe they'll prevail, maybe they won't, but there's a risk of litigation over it, and that would be refunds plus duties. I'm sorry, refunds of duties plus interest.
Yeah, I would add one more scenario. I would add one more scenario to that, and that is the importer has said, sorry, I cannot keep my price. I need to, you need to pay 15% more because I need to pay the tariffs. And they made that statement to maybe even to the consumers. And now they get a refund and then they keep the money. And then I would say that's probably dicey when it comes to false claims and so forth, and also contractually. They have made a promise, or they said, my prices are based on the tariffs, and now they get the money back and they don't pass it on. Wouldn't you agree?
Right. Yes, you could see that. Like there's a windfall to the importer. The importer pays the tariffs, then passes that cost on to the consumer, and then gets the tariffs all back, but the consumer has already paid the tariff. So there's a windfall to the importer. I don't know legally in terms of anyone that they don't have an express contract with. That seems to me a more difficult case, but I certainly have heard attorneys make a colorable claim that there may be obligations to the consumer as well.
Going through the terms of a contract with regard to price increases, to regulatory duties, government duties that have been imposed, and how those are addressed in the contract is going to be very important. And then, of course, depending upon the amount of the transactions and the percentage of a financial cost that has imposed on the customer is probably going to dictate, the extent to which they want to pursue certain types of remedies. But Roger, I think, as you said, we don't know yet how long it's going to take for the underlying issue of refunds to get through the courts. But at the same time, I am sure that there will be folks who will want to know, if it does go through, what are my remedies against, my broker, the people who sold me the parts, the components, the products, because that's imposed additional conditions. And then, is there a consumer element to it? But I think in the time we have left, Axel, I wanted to ask you about the European perspective. The UK seemed to indicate in the press that they would uphold the trade agreement that they negotiated with the United States. There is a treaty that is pending right now before the European Parliament, I believe, which The vote was put immediately on hold. I don't know what developments have happened since then. The administration seems to be confident that these new treaties, the impetus for which and the pressure for the negotiation has been the administration's imposition of large tariff percentages in the past year. Now that the court has ruled on them, what are we looking at? Are we seeing a rebalance of power? Are we seeing, do we believe that the pending treaties are likely to go forth? And what's the mood in Europe?
Well, there are members at the European Parliament who feel so strong right now that they cannot even really walk because they have so much muscles. So they really think that they claim victory here, and they say that the European Union should not ratify the agreements with the Trump administration, should put that on hold and pull out the so-called bazooka, which means the biggest trade weapon that they have to retaliate just in case and really show their strengths. So I don't know where that's going, and but they feel more invigorated. And another issue that I hear a lot, and maybe we can talk about in the remaining time, is a retroactive application of potential laws or other regulations. I'm still reminded in my law classes at Bonn University, constitutional law, and there was a professor, I think we even had a test on that, that talked about a retroactive healing of anti-constitutional situations, and there are some theories there when it is allowed, when it's not allowed. I understand that here in the US, there is the possibility to come up with a law and to quote unquote overrule the Supreme Court and to make the government whole. If you could comment on that, it would be great. I think there is a great interest on that.
That's an excellent point, because as I think we mentioned in the beginning, the administration has imposed Section 122 of the Trade Act by imposing a temporary maximum amount, 15% tax on all imports across the globe. That has a time limit on it of 150 days, after which Congress must act. But there's other provisions such as Section 232 or 301. 301, as we know, has mostly been used on China tariffs. So the question of whether that statutory authority would grant them the ability to impose such tariffs retroactively to undercut the argument for a refund, or does that violate, the principle of an ex post facto law, something that happens after the fact, such that it's the retroactive application would be against legal principles. But Roger, what do you think?
It's a big topic. There's certainly there is authority for imposing retroactive tariffs. Has been upheld by the Court of Appeals for the Federal Circuit and also by the Supreme Court. There are two grounds for challenging that. One is the ex post facto clause in the Constitution, as you say, and then there's also due process challenges that have been made. But I would say there's definitely a possibility. I can see two scenarios where refunds could be offset or canceled by a retroactive imposition of tariffs. One is, and I don't see it happening at present, but Congress could simply amend, I say simply because the language would be fairly simple, amend the IEEPA statute to say, as you mentioned, Axel, that regulation of imports does in fact include imposing tariffs, and the president has authority to impose tariffs and effectively overrule the Supreme Court on this case. Then he could say that they apply retroactively in the statute, or the administration could simply apply them retroactively. That would be another whole area of litigation, which could extend even further the resolution of refund claims.
And with midterms coming up, the likelihood, I think, of that kind of action anytime in the near future is probably pretty low. But it is an interesting point. It's an interesting point.
Yeah.
Sorry, please continue.
Yeah, I think so. Yeah, and there's actually a case that's directly on point from, I think, about 2014, maybe, on an anti-dumping duties, which were imposed retroactively based on an amendment of a statute. And because the court had originally held that the way the countervailing duty or anti-dumping duty was imposed was not authorized. And then Congress amended the statute to authorize them. And then the question was, well, does this nullify the court's earlier decision, or does it simply amend it? If it nullifies it, then the tariffs were imposed properly. That is, they were always authorized. The court's decision just sort of disappears. And the other option is no, they were authorized until the act. Now they're authorized, but the ones that were already paid were not paid under the law and should be refunded. So that it gets into a lot of very specific, case-specific, fact-specific issues. So the other way, apart from the IEPA statute, is as you say, the president has authority to impose tariffs under a number of different statutes, including the ones you mentioned, 301, 232. There's also Section 201, which allows for the imposition of tariffs on goods when there's an increase in quantity that occurs. All of these could be imposed retroactively, and then probably challenged as an ex post facto or a violation of due process.
Right. So I
understand that the situation at Congress right now is not that they would really be willing to do that, right? I mean, they could have done it a long time ago. The writing was on the wall, and
exactly.
They haven't. So is there really some tangible action right now, or do we have to wait and see what happens in the next few weeks?
I've heard members of Congress speak of it recently. Since our last conversation, I heard a couple members say something about it, but I think it's difficult because I'm not an expert on this, but I see that the tariffs are portrayed in the media as something that's it's perceived as contrary to economic well-being of consumers. So so as a matter of with the election approaching, it could be seen as a liability to then amend the statute so that the tariffs are imposed again.
Until
but I don't know.
Administration changes, and then the other party decides it's in their best interest. So there's always that danger. But I think the underlying theme here is that there's still a lot in play. Companies need to investigate and preserve their rights to file a protest or a claim in the Court of International Trade if there's a sufficient economic impact or financial impact to be had here. And the extent to which additional tariffs under other authorities, more than the temporary ones, have been imposed it remains to be seen. And there's still some question as to whether any of the tax treaties that have not yet been signed will be renegotiated, will be signed as is, or even the ones that have been signed and executed before they've been ratified, will they go back to the table on a couple of issues at this point? I think perhaps when we have a future discussion of these kinds of issues, we should invite an economist as well to get that financial perspective. Although no disrespect to our colleagues, that might double the length of our conversation. As it is, it's hard enough for us lawyers to keep to 30 minutes. But
yeah,
I want to thank my colleagues, Roger and Axel here for a very lively and informative discussion. Our international trade practice, of course, is here to help companies with their specific questions based on their industry, their business, and their priorities. And thank you very much. And we hope to see you all at another one of our discussions.